So Daryl, I came by today because I have a client that has some property. He's buying some more property. And I remembered when we were out chit-chatting a few weeks ago, you mentioned that you had something with property tax and I think a limited liability company, but I don't remember exactly how it worked.
Okay. Um, yeah, we've had some great results for clients who structure their purchases of real estate the right way in terms of keeping the property taxes low for many, many years, akin to a legacy trust.
A legacy trust is a trust what lasts forever, or how long can they last for?
From generation to generation without property tax reassessment, so that the property tax will stay low as it is now, rather than being recalculated and increased when the value of the property increases over time.
So, as in California, as I know, we have this Prop 13. So the basis usually stays the same when you buy it if you don't change anything. But if somebody comes into the family or if there's a death or divorce, sometimes there's a reassessment. So how does that work then? What do you do to keep that low property 13 tax basis?
Generally speaking, the property tax is reassessed upon a change in ownership. We like to shorten that to CIO, change in ownership.
Okay.
So what we're typically looking for is an exemption from the reassessment. So there might be a change in ownership technically, but we're looking for an exemption. One of the ways of avoiding reassessment over time that is often overlooked is to have the property acquired from the outset by an entity, an LLC or a limited partnership. Once it's acquired and then owned subsequently by the entity can change its partners, give away shares, bequeath them to the next line of family members, the next generation, with no change in the property tax, because the assessor views it as something that's allowed, a continuing partnership, for instance. You can just keep changing the partners, and they don't mind. In an LLC, keep changing the members, they don't care. But the key there is it had to be acquired in the name of the LLC. So when I get calls like yours or questions like yours where I'm asked, gee, we're about to close escrow, in what form should we take ownership? I encourage them, if they are going to do an entity ownership, ultimately an LLC or an LP, which is a different question whether you want to have it in the entity, at least from property tax. If you're dead set on owning it in the LLC, do that from the start. Acquire it in the name of the LLC. Don't wait until a day or weeks after the close of escrow. And that's because if you do it afterwards, you're transferring in the ownership of the property into the entity, and you're relying on something called Revenue and Taxation Code 62A2, which allows you an exemption from reassessment when you put proportionate interest. So if you and I own the LLC 50-50, but we held the piece of property outside the LLC, and then we rely on this exemption, proportionate exemption transfer, we put it in the LLC and rely on that. Once we've done that, we are vitiated or contaminated. We're called original co-owners. And then we're subject to a whole different area of law where we will suffer a reassessment when there's a greater than 50% change in the ownership of our entity. So, cumulatively more. So when you and I die, we'll have passed on our interest to other persons, and there'll be a reassessment. But if we had had the foresight to acquire our property in the name of the entity from the outset, we wouldn't be vitiated or contaminated with that original co-ownership status.
So the original co-ownership is a little bit like the original sin. It never goes away.
I think that's an interesting way to look at it.
Yeah, in fact, so too. Now, so let me talk about estate planning. Let me back up a little bit, because estate planning is the parent generally has the property for a long time. In this case, an LLC membership share. Property goes up in value. They do a sale to an estate planning trust, quite often they take back a promissory note. So those can actually be a sales transaction because we needed to show the sale to the IRS to get it out of the taxable state. So what is the county assessor going to do when we sell that LLC membership share to the trust?
Well, there are various statutes and, in fact, a provision in the California Constitution which exempt transfers in and out of trust. I would have to know more about the particulars of the transaction before I could opine that it would indeed be exempt from reassessment. But there are numerous exemptions pertaining to trust. You can do a lot in and out of trust that are exempt from reassessment. But
Do you file something? Back to my example. So when the LLC share was sold to the estate planning trust, I remember on the LLC partnership form for California, Form 565 for California, they ask you if you transferred more than 50% of the shares of the LLC. So did you transfer less? You transfer 45%? So you can answer that box no? Or what's that step?
That's one way to do it, but ultimately, cumulatively, there may be a transfer of more. But I guess once it's in the trust, perhaps you'll avoid that. So that seems to be one way to do it.
Great.
Okay. So, but back to your client who's about to acquire some property. Have him give me a call, Daryl Miller, of course.
And your number is?
949-955-3570.
Great. Thanks, Daryl.
You bet.